Hey everybody, Mo Hashim here with Flat Fee Landlord Property Management, serving Northern Virginia, Washington DC, and Maryland. Today I want to discuss a common question that comes in from existing landlords of how they could have prevented it, and also of new landlords, which is what can I do to protect myself from our tenant breaking our Northern Virginia lease early. And I just want to go into it because it happens often, whether you're a current landlord and your tenant reaches out to you and says, hey, I got to break the lease early. You're not really sure what you are allowed to do or what you have to hold them responsible for. And then there's people that are just planning ahead and have heard horror stories in the past. And I just want to take a minute to go through and touch base on certain things you're required to do by law and other things you can put into place to protect yourself, so that you don't get put in a situation where you're scrambling to try to find out what to do once your home sits vacant, or if it really should be sitting vacant to begin with. So to start out, we can talk about when are you legally obligated to allow a tenant to break the lease. And one of the most common instances that happen, especially in this area, because of the high influx of military personnel and National Guard, is going to be because of the Service Members Civil Relief Act. And what that stipulates is basically if the tenant is a member, an active member of either the National Guard or the military, they are able to break the lease given a 30-day notice to the landlord if they have to relocate due to active orders. So the key, there's some key words here. They have to be active members, and they have to relocate because of due to orders from the military or the National Guard. So if you run into that situation as a landlord, and you want to verify those things, that's what I'd recommend you do, is verify it. You want to, to start beforehand, before you even get to this point in your application. When the tenant submits an application, you want to ask if they are a member of the armed forces to begin with. And then also, if an issue does come up where they approach you and say that they have to leave break the lease early because of active orders, you just simply ask for a copy of the orders. Again, in those situations, you will just have to oblige by it, and unfortunately, that's just what you have to do as a landlord in that situation. Other situations that would come up where you may have to allow the tenant to break the lease early would be death to one of the tenants. Those do unfortunately come up, and certain instances you would have to allow the remaining tenant to break the lease if another tenant on the lease has died, and because of hardship they can no longer afford to rent that property. Again, that's typically done in a certain time frame. If somebody dies, unfortunately somebody dies, and then 3 years down the road the tenant says, hey, I have to break the lease because of it, well, there's a statute of limitations, and generally that's written out in your lease of what that time frame is of when they would have to give their notice to break the lease. Other things that you'd want to keep in mind when you're not dealing with either of those two situations is being very thorough in your lease and really outlining the steps or what it takes to break the lease in your lease. And this is before they even sign up to rent your property. So some things that you could do is some leases don't allow it, which pretty much it comes to negotiation during the lease of what you and the tenant feel comfortable doing. I generally don't recommend it because it's better to just lay out all your options ahead of time as opposed to try to figure it out after the fact something's come up. So I generally try to recommend putting clauses in your lease that really stipulate ahead of time what would happen in certain different situations and how to go about breaking that lease. For example, something that we recommend in the lease is really outlining, hey, if you do have to break the lease, here's what you have to do. There's a certain fee associated with it. You're responsible for the property up until the time a new tenant has been found. You can talk about who would be responsible for finding the tenant, whether it's the landlord's agent, or the tenant themselves, and also outlining the costs associated with that. For the landlord, if they're going through an agent or even on their own, if they're doing it, there's certain costs with finding a new tenant. So if a tenant has to break the lease at no fault of yours, then that's something you want to articulate in the lease so that the tenant knows that they are responsible for those costs while a new tenant is being found or once a new tenant has been found. So that's generally the biggest thing that I recommend, is be upfront, think about it, include it in the lease, and that way if the issue comes up down the road, both parties already know ahead of time what needs to be done, what can be done, and how to go about doing that. If you got any other questions regarding breaking the lease or a lease in general in Northern Virginia, DC, or Washington, feel free to give us a call. You can also check out our website at flatfeelandlord.com.